Hey, good afternoon. Good afternoon,
Good
Attorney
afternoon.
Walsh. Good afternoon, Ms. Estrada. Ms. Estrada, just so you know, this is being recorded. We are on Zoom, so your phone call is being recorded. Attorney Walsh is on camera, and he has audio, and he will be recorded as well. This is docket 2023-J-0432. My name is Judge D'Angelo, and I am the single justice for this session. So with this, Ms. Estrada, I will hear from you because this is your appeal.
Okay. We're talking about the bonds and the amount for use and occupancy.
Yes, both of those issues.
I am indigent, whatever you call it. I can't indigent. I cannot afford to pay that amount, $1,200 plus $163, without depriving two of my dependents. I get altogether three SSI checks, and I have to like spread it all around on other bills too. So I can't pay that amount.
All right. And what issue do you feel on appeal is one that you think is what we call meritorious?
Is this talking about with the trial?
Yes.
That okay, so I feel it would be meritorious because in the rules applied in my case, it's merit for, oh my God, it's just because I felt the procedure was unconstitutional. The rules, Rule 56, Rule 50, and Rule 26 was unconstitutional. I did not have any right. It deprived my right to defenses. Like, it just deprived me of, I couldn't file anything. I couldn't present evidence. I couldn't file motions to stay. I was just denied due process the whole time. So.
Okay. Looking at the paperwork, there was a hearing that you had in front of a judge. Is that correct?
Yes.
Okay. And when you say that you were not able to present anything, what do you mean by that?
I mean, on the day of court, I brought evidence. This is like, I disagreed with the amount they say I owe in arrears. I had disagreed with that. I don't owe anything because I promised to pay $1,000 monthly. So, and could you repeat that? I'm sorry.
Well, you said that you were deprived your right to present anything.
Oh, okay.
And I'm trying to figure out I need you to be more specific about that.
Okay. I tried to present evidence that in my case where the Board of Health came to my apartment, I tried to produce, there was a hearing at the Board of Health. There was a hearing at the Board of Health. I tried to file a motion to stay, and they said, no, it's too late. And it was the same day of court. They said, no, it's too late. And even from the beginning, like the court's clerk said, you're going to lose anyway, so you might as well, make an agreement with the other party and just move. So it started out like that and ended like that. We couldn't even, remove the fault from my son not showing up because for a good cause, he fell. And so he was like, he had a disabled, he couldn't show up. And there was like no information about him appearing if he couldn't physically appear. And I couldn't even do that. Everything was no, you can't. So the summary motion was all about, there was no genuine issues as to material fact. And I disagree because there were many.
All right. Anything else you'd like to add before I allow Attorney Walsh to speak?
No, that's it.
All right. Then I'll just ask you to hold on and not to speak because now it's Attorney Walsh's turn to present his case. Attorney Walsh, go right ahead, sir.
Your Honor, first of all, I think as the court knows, this was not a summary judgment issue. This was a full-fledged trial. Mr. Strato was allowed to present testimony. There were no defenses to possession raised at trial. The only defense, well, it wasn't defense, but the only issue that was raised was that the prior owner allegedly did not transfer a security deposit to the present owner who brought this action, which has really nothing to do with this case and is not a defense to possession. But there was a full and fair opportunity for everybody to be heard. As a matter of fact, Mr. Strato was heard on the issue of use and occupancy, and the judge found that although my client thought rent was $1,200, that what determined that Mr. Strato never agreed to that rent increase and actually set the use and occupancy to $1,000. But it was a full and fair trial. There were simply no defenses to possession raised.
And Attorney Walsh, how much, assuming the amount is $1,000, which is what the lower judge ordered, how much is currently outstanding?
I guess the appeal bond hasn't taken effect now because of this appeal. But I don't think anything is outstanding at present.
Okay.
I believe Mr. Strato would owe an extra $200 now because going forward, use and occupancy should be at market rent.
All right. Okay. Thank you both very much. I will issue a decision on this fairly quickly so you both know what happens next. Thank you all.
Thank you, Ron.
Okay,